Thank you. So let's start and welcome to our session on pricing algorithms and antitrust. Thank you for being here. Thanks to our panelists and thanks to Lea for organizing this beautiful event. It is a matter of fact that pricing algorithms and the use of pricing algorithms is booming. Not only in the digital industry, but also in the traditional industry, boosted by big data and artificial intelligence. All this is under the radar of antitrust agencies, courts, legislators, policymakers, because while it is understood that pricing algorithms can bring efficiencies, there is the perception, on the other hand, that they could increase the risk of collusion or harm competition in other ways. In the United States, plaintiffs started litigation against providers of pricing algorithms, such as RealPage in the market for apartment rentals, or Rainmaker in the hotel industry, and also against their clients, arguing that they were part of an illegal hub and spoke scheme for price fixing. The DOJ made statements opposing the motion to dismiss the claims, supported the idea that the widespread use of pricing algorithms is something that needs to be carefully scrutinized. Bills were proposed to the US Senate to introduce specific remedies in order to prevent algorithmic collusion. And coming to this side of the Atlantic, as you know, the EU Commission and the CMA in UK are both dealing with pricing algorithms in their guidelines on horizontal agreements released last year. At national level, the antitrust authority has been given a new tool for market investigation. And as you know, the first investigation based on this new tool is about pricing algorithms in the air transport sector. We will discuss these topics with our distinguished panelists that I'm very pleased and honored to introduce. Joe Harrington, professor in the Department of Business Economics and Public Policies at the Wharton School, University of Pennsylvania. He has conducted extensive research on cartels and collusion, paying specific attention in his work on third-party pricing algorithms. Mariana Filippelli, professor of business law at the Sapienza University of Rome. Her research focuses on corporate governance and competition law, and I guess that tacit collusion is one of her favorite topics. Chiara Bonassi, senior economist of the Italian Competition Authority. She currently works at the Chief Economist's Office, supporting the enforcement of competition law as regards mergers, anti-competitive agreements, and unilateral conducts. Last but not least, Domenico Gullo, my colleague and friend at the LA Piper, who will bring in the discussion the perspective of an antitrust lawyer. So I think we will start with Joe. Joe, the floor is yours.
Okay, thank you, Alessandro. It's a pleasure to be here. It's been an exciting day. There are many competition policy issues connected to AI and algorithms, but my remarks are going to focus on when competitors in a market use a pricing algorithm supplied by the same third party, such as a data analytics company. Now, while the discussion will largely refer to U.S. cases and U.S. competition law, the issues are just as relevant in the EU as the challenges they pose for Section 1 of the Sherman Act apply as well to Article 101. So while the cases aren't here yet, rest assured, they will come. One of the implications of big data and AI is that firms can now outsource their pricing to a third party. The firms share confidential data, such as past prices and sales, with a third party who then uses it to train a pricing algorithm. Current market data is then inputted into the pricing algorithm to generate recommended prices. Finally, a subscribing firm then decides whether or not to implement those recommended prices. The use of a third party's pricing algorithm is occurring in various markets, including petrol, apartment rentals, hotels, and other products and services. Now, like any input, a firm makes a make or buy decision, whether to supply the input themselves or outsource it. Here, the input just happens to be a pricing algorithm. A third party may be able to develop a better pricing algorithm because it has more experience and expertise, more data, and stronger incentives to invest as they can license it to many firms. What this means is that there are pro-competitive efficiencies from outsourcing pricing to a third party, but at the same time, there's the risk of anti-competitive harm when competitors in a market all use a pricing algorithm supplied by the same third party. Now, in fact, according to complaints in approximately 30 class action suits in the US, these possible anti-competitive effects have become a reality as they claim there is an unlawful agreement between a data analytics company and subscribing firms in the market for apartment rentals and the market for hotels. Now, furthermore, about 1 month ago, the Antitrust Division of the U.S. Department of Justice filed its own case in the market for apartment rentals. Now, of course, these complaints are just claiming effect, but there have been some recent empirical studies showing actual harmful effect. In the German petrol market, a recent study found that prices are higher when both stations in a duopoly market adopt a third party's pricing algorithm, but they are not higher when just one firm or one station adopts. And so that's clear evidence of anti-competitive effect. In the U.S. apartment rentals market, an empirical study shows that adoption of data analytic company RealPage's pricing algorithm raises prices when demand is strong, but it lowers prices when demand is weak, and that's relative to not adopting. That is a pro-competitive effect, something we expect the data analytics company to deliver, making price more sensitive to demand variation. But they also find some evidence of higher average prices, so some evidence of anti-competitive effect. Now, interestingly, the private litigants and the DOJ have taken different approaches to pursuing their cases against third-party RealPage and apartment property owners. The private litigants claim there is a price-fixing agreement in the form of a hub-and-spoke cartel, where RealPage is the hub and the spokes are the apartment property owners. And they are arguing this case as a per se or by object violation. In its complaint, the DOJ follows a different path. To begin, the sole defendant in their case is RealPage, which is sufficient for their purposes, as they're not looking for damages, they're looking for injunctive relief, and in particular, to discontinue this information exchange that is occurring between the subscribing firms and RealPage. Their case will be argued under the rule of reason or by effect, which will require showing that any benefits are outweighed by harm to the competitive process and to competitors. So it'll be interesting to see how these two different strategies play out. Let me turn to discussing a couple of challenges that third-party pricing algorithms create for competition law. There's certainly other ones, but let me highlight two. And the first challenge is due to the presence of efficiencies, and that's something that really cannot be lost. But let me begin by noting that the efficiencies provided by a data analytics company do not provide a defense under Article 103, and that's because the efficiencies do not require that there is a price-fixing agreement. Where the challenge lies is in proving liability, and it becomes more difficult because a particular form of circumstantial evidence is no longer available. Specifically, one can draw the inference of an agreement from mutual adoption of some practice by competitors, and that adoption of that practice by a firm is in its best interest only if it anticipates their competitors also adopting it. For example, it is not optimal for a firm to share its prices with competitors unless they were to reciprocate. In that case, mutual adoption cannot be explained as a result of independent conduct. As it is called in the US, this plus factor is not present with third-party pricing algorithms. Because of the efficiency it provides, it can be unilaterally optimal for a firm to adopt the pricing algorithm. Thus, we could observe all firms in a market adopting it, and it could just have been the result of independent conduct. A second challenge comes from the fact that there can be harm in the absence of any agreement or concerted practice, as it is due solely to the unilateral conduct of the third party. A third party could choose to program in a supra-competitive markup without the request, approval, or knowledge of the subscribing firms. And it might do so on its own because by raising subscribers' profits, it could potentially extract some of that through a higher fee for its services. In this situation, intent only resides with the third party. In essence, we have the effect of a price-fixing agreement, but without a conspiracy. Only a third party's unilateral conduct. And the German Monopolies Commission has kind of referred to this as a liability gap, and I believe it is a challenge. Let me just conclude my opening remarks by making a few regarding remedies. And here we come back to the issue of the fact that there are efficiencies here. So a remedy is going to have to prevent anti-competitive harm without unduly interfering with the efficiencies that are provided by a data analytics company. Now, one approach is to restrict the data that is used by the third party. And this is an approach recently pursued by the US Senate, which put forth a bill earlier this year entitled the Preventing Algorithmic Collusion Act of 2024. It would prohibit a third party from using non-public competitor data in recommending a price to a firm. This means that non-public competitor data could not be used to train the pricing algorithm or be inputted into the pricing algorithm to generate a recommended price. For example, RealPage could not use data from apartment owner A to then use that data to recommend a price to apartment owner B. Now, the problem with this proposed remedy is, first of all, it would reduce efficiencies. For example, competitor data is useful for distinguishing between firm-specific and market-wide demand changes, which is relevant information for determining the proper competitive price response. Or consider an entrant into the market. Under this law, it would not be able to benefit from a pricing algorithm trained on the data of more established firms. That is not only inefficient, but it creates an impediment for entry. But there's even a greater concern that I have with this proposed remedy, which is that the data restriction may not prevent the third party from recommending super competitive prices, if that is the third party's goal. Harm is not necessarily generated by the information exchange, but could instead come from the objective used by the third party in training the pricing algorithm. For example, training it to maximize the collective profits of the subscribers. So it's not so much in the data that it's inputted, but rather in the objective of the algorithm. If the US Senate bill were a drug, I would hope that the Food and Drug Administration would not approve it because it has not been shown to be effective in treating the disease, which is super-competitive prices, and is likely to have harmful side effects, which is reducing efficiencies. Rather than restrict the data that is used, an alternative approach is to restrict the objective used to train the pricing algorithm, and that's something which needs to be investigated. So let me just conclude and say that of all the competition policy concerns associated with algorithms, third-party algorithms is the one that is most pressing as cases are occurring and legislation is being proposed. At the same time, it poses serious challenges as we need to balance pro-competitive efficiencies against the risk of anti-competitive harm, which is ever present if some third party is recommending prices to competitors. Still, data analytics companies are supplying a legitimate service, and we must be careful not to kill this market in its incipiency. Okay. Thank you.
Thank you, Joe. Marilena.
Thank you.
Marilena, I just wanted to ask you, based also on what Joe just said, what is your view about the legal approach that should be taken regarding the pricing algorithms?
Yeah, that's the focus of my intervention. So I think discussing about pricing algorithm means moving from a starting point. Algorithms have a remarkable ability to collect, to process, to analyze data, and have the ability to provide immediate and automatic reaction to a given event. And for this reason, they have, of course, a great potential for collusion, which is made clear now in different studies and partially in the case law too. Joe has mentioned some case from the US, other cases were discussed in EU relating on the third-party algorithm as well. So, firstly, algorithm can be adopted as a means to execute agreement, and there is huge case law on this point. Algorithm can be adopted as a factor facilitating collusion, especially as a means to exchange sensitive information. For example, companies can share the same algorithm or can use third-party algorithm. And third, and this is the focus of my speech, algorithms may perhaps collude autonomously. They are not designed to collude, but they may choose to collude. So it's the case of so-called self-learning algorithm exploiting artificial intelligence. They can explore the market, they can learn to interact with each other, and left free to set their profit maximizing strategy, they can autonomously choose to collude. Without communicating with each other, without any human intervention, without executing orders, simply by adopting autonomous individuals' unconcerted strategies. This last scenario is right now the most controversial, but there is growing evidence on this regard since a seminal study published by Professor Calzolari in 2020. So in this case, collusion rises from a mechanism of mutual observation and best response, precisely like it happens in oligopoly. So for the case of tacit oligopolistic collusion. But this collusion is more effective because algorithms can easily collect a huge amount of data, can easily observe rivals, can detect defection, can react to defection. So algorithms may collude more efficiently than humans. And for this reason, algorithmic collusion can expand far beyond oligopoly. And this scenario, of course, raises an issue of proper antitrust enforcement. In our experience in both the EU and US, the antitrust enforcement against collusion has been, on the whole, weak. Basically, I think because it is still dominant the belief that collusion cannot be genuinely tacit, and that some plus factors facilitating collusion is needed, and in most of the case, this factor is information exchange. Therefore, it's dominant the belief that if no plus factor is found, then there is no unlawful collusion because that alignment of conduct comes from unilateral strategy, unconcerted strategy. In other words, in our experience, the enforcement of cartel rules against collusion is based in Europe and in the US too, is based on evidence of meeting of minds, evidence of concertation, of conscious, if not intentional behavior, and this element is typically inferred from information exchange with the result of substantial under-enforcement. In the case of tacit collusion, it's the oligopoly paradox. So what can we expect for the case of algorithmic collusion? Alessandro mentioned it before the 2023 Horizontal Guideline on Cooperation Agreement, where the Commission acknowledged the potential of algorithms for collusion and makes it clear that companies cannot avoid antitrust liability on the ground that their prices were determined by algorithms. So it solves, in a way, the issue of liability for the conduct realized by or through algorithm. When going into the potential of algorithm for collusion, the guideline, again, recognized the capacity of algorithm to facilitate information exchange between competitors and acknowledge the positive role of information exchange in improving the training process of algorithms. So the focus seems still put on information exchange, while no mention is made to tacit algorithmic collusion, which probably means that in the Commission view, the scenario of tacit algorithmic collusion is not realistic, or perhaps not yet realistic. And this approach, I think, is quite questionable in terms of effective antitrust control because it gives companies a sort of green light. It signals that it is unlikely that antitrust rule will be enforced in this area, and this, of course, raises a question, a matter of deterrence, not just enforcement, but also deterrence. Of course, the antitrust enforcement in this area is very complex, just as it is in the case of oligopoly, but I think that the choice cannot be to refrain from intervening. The question is rather, is there room for any antitrust intervention against companies which use autonomous algorithms that interact to each other and raises anti-competitive effect? Well, I think that we could apply in this area the same approaches suggested for the case of oligopolistic collusion, and I have to admit, not particularly successful in that area so far. But on the whole, the proposal formulated for the case of oligopolistic collusion and applied, in my view, also in the case of algorithmic collusion, they all imply an attempt to overcome the obstacle of showing a meeting of mind behind parallelism of conduct. So the first possibility on this regard is to apply Article 101 and qualifying tacit algorithmic collusion as a concerted practice. There are some proposals in this regard based on a new evolutive interpretation of concerted practices, which consider parallelism of conduct and anti-competitive effect as the sole essential element of the prohibition. The other factors, conscious or intentional conduct, the meeting of mind, would be necessary not to establish an infringement, but just to impose fine, because fines, of course, require evidence of at least negligent conduct. So in this case, fine cannot be imposed, of course, because we don't have evidence of negligence or intentionality, but the authority could impose remedies, so injunction and remedies. In the US, a similar result could be achieved by applying Section 5 of the Federal Trade Commission Act. The second possibility, and this is perhaps a more realistic scenario, is to apply Article 102 and qualifying tacit algorithmic collusion as an abuse of collective dominance. And this approach exploits the objective notion of abuse of dominance, which does not require in itself evidence of meeting of mind, of concertation, and therefore no evidence of information exchange, and it's based on the interpretation of dominance in terms of market power, consistently with economic theory. So antitrust infringement require evidence of anti-competitive effect, and anti-competitive effect can occur just when companies hold market power. If there is a relevant effect, then there is market power. Under this perspective, companies acting in parallel, and in our case, companies using algorithms able to act in parallel and rising anti-competitive effect, hold joint market power, which they exploit in an abusive way. This scenario is more realistic, relatively more realistic, because the European Court of Justice has admitted since the 90s that Article 102 can apply in the case of tacit collusion. In fact, it has never been applied in case of pure tacit collusion, but it could. Again, even in this case, absent any subjective element, no fine can be imposed, but just remedies. And there is a third possibility in Italy and some member states. Chiara will discuss this in a while, and rely with the use of new competition tools. All these proposals have the same consequence. The enforcement is limited to remedies, so injunction and remedies, and so they all raise the issue of designing proper antitrust remedies, which in the case of algorithmic prices could be even more challenging than in oligopoly, but I think we'll discuss remedy later in this section. Thank you.
Thank you, Marilena. And now, Chiara, we would like to hear from you from the angle of the enforcer. What do you think? We know that now there is no longer the need to find an infringement under competition law to impose remedies.
So first of all, thank you very much for the invitation. For me today it's a pleasure to be here and to share this floor with you. So let me start with a general framework that maybe allow us to somehow recall why we are here today to discuss such hot topics. The first reason is linked to the, as Alessandro already mentioned, to the pervasive rule of algorithms. Probably all of us have experienced in our day life this pervasive rule. In fact, algorithms do not involve just online markets, but also traditional ones. That influence different dimensions that impact consumer choices. For instance, choice architecture, that is the way products are presented to consumers, and also prices. And in this sense, AI probably favored a transition from static to more advanced dynamic pricing algorithms. The third reason is that their relevance is expected to grow due to an advancement of AI techniques. So large availability of data have led firms to have a better knowledge about consumers and to have better predictions of their competitors' behavior. And in this sense, pricing algorithms are deemed to spur the rise, the surge of two already existing phenomena that are price discrimination and the risk of collusion. These two phenomena have been seen traditionally as alternative. In fact, price discrimination tends to reduce transparency on the market, making deviations from collusive equilibria less detectable and ultimately undermining their ability. However, recent studies also highlighted that ban on price discrimination can help reduce the risk of collusion, and implying that there can be a positive correlation between these two phenomena. So now, focusing just now on price discrimination, as Joseph and Marilena already discussed extensively on the link between algorithms and the risk of collusion. We can say that probably now price discrimination is more feasible due to the presence, due to the usage of algorithms that have reduced the cost of collection, storage, and analysis of data. So in this sense, probably price algorithms have revitalized an old debate regarding the impact of price discrimination on consumer welfare. And the economic debate tells us that price discrimination poses some distribution issues, first of all among consumers, and in this sense, these effects are somehow neutral from antitrust perspective. But also, price discrimination has an impact on total welfare. In fact, it increases efficiency. Discrimination, intertemporal price discrimination allows firms to give a real-time response to fluctuations in supply and demand, improving the functioning of the market by optimal price discovery. And so, in this sense, it has positive benefits on allocative efficiency, but also price discrimination tends to have a market expansion effect. In fact, firms can charge lower prices to consumers with a lower willingness to pay, who otherwise, under a uniform price-setting algorithms, would be underserved. So this quite positive framework gets more complex if we think that algorithms can now use more granular data, especially the individual consumers' data, like, for instance, their browsing and shopping history, or information related to the device they use, or their income, their location. And these are the motivations for which, for instance, the FTC also launched an investigation into these kinds of issues, I think, this month. So the impact of personalization on consumer welfare is not straightforward. In fact, economic literature tells us that there are some benefits. These benefits are mostly shared with the price discrimination in general, and in particular, these benefits can be related to the market expansion effect, but also personalization can lead to lower prices due to tough competition on each consumer. Other studies have highlighted that there can be potential competitive concerns that are related, for instance, to an asymmetric adoption of personalization due to an asymmetric accumulation of data that can make the position of dominant players less contestable. Another issue is related to the lack of transparency on whether and how firms make use of algorithms to discriminate among consumers, preventing them to make informed choices. And an example, the potential concerns is the very recent investigation launched by the CMA into the Ticketmaster over the concert sales. In any case, it seems that the impact of personalization can depend on market characteristics, like partial or full coverage of the market, and on the preferences of consumers. In addition, empirical evidence on how widespread is first-degree price discrimination is not conclusive. In fact, in the past, some reports have found evidence of this didn't found evidence of this phenomenon, like for instance, the study for the European Parliament of 2022 and the study for the European Commission of 2018. But other recent studies instead find evidence of personalization, at least in some markets, for instance, in the online grocery markets in US. So according to this setting, to this framework, it's key, it's crucial to wonder, to identify the challenges, the main challenges for antitrust authorities. I identified two main challenges. The first one is about the possibility for the antitrust agencies to intervene. And the second step is about the proper tool to intervene. For what concerns the first step, I think that a case-by-case approach is maybe the most suitable one. In fact, as already said, impact of discrimination on consumer welfare is not clear-cut, as it depends on some conditions like market characteristics, degree of discrimination, the level of transparency given to consumers. Another aspect that is related to this issue is about the technical skills that agencies should be endowed with in order to understand the impact of algorithms on the functioning of the markets. And from the Italian antitrust agency's perspective, probably the use of external technical experts can be helpful, because outsourcing part of the analysis gets the results more consistent and also more timely. And we have caught this opportunity within the market investigation we launched in the airline transport sector. Moreover, the very recent establishment of the data science unit at ICA can be helpful in the sense that it can allows to fill the gap between the two disciplines that are mostly involved and related to these issues, that are economics and data science. These disciplines are not alternative. I believe that there is still room for economics, especially for prioritization of intervention. In fact, in a world with scarce resources, it's key to focus intervention in the sectors where this phenomenon is more likely to occur. The second step is about the selection of the most appropriate tool. This choice is not easy at all. Probably consumer protection is best placed to tackle transparency profiles. And in fact, information obligations are set in the Omnibus Directive and transposed into our National Consumer Code. These are obligations related to personalization when it relies on an automated decision making. So in this context, the Italian Competition Authority is well positioned given its dual competencies in competition policy and consumer protection law. And in fact, the Italian agency has already explored these issues. For instance, in an investigation for potential infringement of the rules on unfair commercial practices by Vueling. This is a very recent case closed with commitments aimed to address precisely the lack of clear information on the fact that the price of ancillary services related to the airline transport services could vary depending on the purchase channel chosen by consumers. Finally, I'd like to stress the fact that, as already Marilena said, we can rely on the new competition tool that is the possibility for us to launch market investigation that could result in imposition of remedies. And we, in fact, already caught this opportunity precisely to investigate the spread and usage of pricing algorithms in the air transport sector. So thank you very much.
Thank you very much, Chiara. And now, Domenico, what are your thoughts?
Thank you very much, Alessandro. First of all, many thanks to the speakers for the very interesting contribution to the discussion. Personally, I think that the issues we are dealing with are a priority both for the competition authorities but also for the undertakings. In particular for this latter, to minimize the antitrust risks possibly stemming from the use of algorithms and to prevent any disruption of their business model. In this respect, I would address a couple of questions because I think that we have a few minutes to the speakers. Since pricing algorithms pose a new challenge for the current toolbox of European competition law, especially when they are programmed to set supra-competitive prices and without an agreement among the parties, I'm wondering how can undertakings reduce the antitrust risk attached to the adoption of pricing algorithms? And in addition to this general question, in particular, probably I don't know if Marilena is the best placed from a legal perspective, how to deal with the implications in terms of legal certainty and presumption of innocence when establishing a breach of Article 101 in the absence of any proof of the meeting of minds. And Joe, and of course Chiara, from an economic perspective, which criteria should companies take into account when deciding whether to adopt a price algorithm or not in order to minimize antitrust risks? I don't know if Marilena wants to start or Joe.
Thank you. Thank you, Domenico. So In thinking about this question, one of the things I did was to go back through the complaints and to see what the plaintiffs were basically accusing the firms of and seeing that as evidence that they were in violation of the law. And a couple things came through in terms of looking at that. One piece of advice, and what I do is I kind of give the advice and then kind of say what's kind of behind that, is that if a company is going to adopt a pricing algorithm, they should make very clear that they're retaining price discretion. They are not delegating pricing to the third party. The third party is providing recommendations, and the ultimate authority to ultimate decision, whether to implement it, still resides with the firm. Because the plaintiffs in these cases are really emphasizing that are claiming that the subscribing firms delegated pricing to this third party, that in some cases they used a feature, and these are all cases against RealPage and the apartment rental market and their subscribers, a feature called Autopilot, which would automatically take their recommendations and implement them. There was accusations that when a company did not implement the recommended price, that someone from RealPage would call up the subscribing firm, talk to their boss, kind of try to, in essence, find out, well, why didn't you, and try to pressure them. And so one thing is to make clear that these are just recommendations and that they're not necessarily going to be implemented. A second point to come out is a piece of advice is you do not communicate with other subscribers or be very cautious about this. The RealPage case, there's actually a documented episode where the subscribers could take advantage of a user group set up by RealPage at which they started talking about renewal terms, not to make concessions with the prospective rentees and lessors. And so, as always, you know, these companies, if they're going to use these pricing algorithms, should not be talking to the other subscribers. A third one is important for a subscriber to limit what they know about competitors. Obviously, you shouldn't share price recommendations provided by the third party, but in particular, should not seek to learn who else is subscribing. Because in these cases, they're trying to argue, the plaintiff is trying to argue that this was commonly known who was subscribing, and that this would be obviously an essential element to making the case that there's an agreement. So don't go out there trying to figure out who else is subscribing. And in fact, there's even documentation related to that of one subscriber publicly making a public announcement to encourage other companies to subscribe, that this is a great service and you'll all do better to do so. Once again, that's verboten, you shouldn't be doing that. Another piece of advice is stick to the algorithm. You know, if this is all about data analytics, then you give your data, you get your recommended price, don't do anything else outside of that. And where this has come up in the RealPage case is there's been talking about, RealPage has been given advice about don't negotiate, don't make concessions. The algorithm is not providing that information. That's just going to be serving to kind of coordinate conduct in an unlawful way. And the last thing I'll just mention, it'll be interesting to see whether this proves to be a safe harbor in the US, but one of the subscribers to RealPage, Avalon Bay, actually made a feature of their contract that RealPage would not share Avalon Bay's data, would not use Avalon Bay's data to make recommendation to other firms, and furthermore, other firms' data would not be used in making recommendations to Avalon Bay. So trying to silo basically the use of Avalon Bay's data. Avalon Bay was originally a defendant in the case, and then the plaintiff voluntarily dismissed them from the case. So that could be a safe harbor, but on the other hand, Avalon Bay is going to lose a lot of efficiencies by the fact that their algorithm is trained only on their own data. So there's some initial thoughts on that.
Very good question. First, the presumption of innocence is, of course, a good point. And in the antitrust debate, there is growing reference to the presumption of innocence, which is typical of the criminal law. And this, in a way, aligns with the thesis that our means European antitrust system is a quasi-criminal law. I'm quite skeptical in this regard because our antitrust law is an administrative law, is not a criminal law. And to the best of my knowledge, but I may be wrong, the Court of Justice has mentioned the presumption of innocence just in hybrid cases involving both antitrust and criminal offenses. I think it's more consistent with our system, but again, the opposite view is gaining consensus, so it's my view. But I think it's more consistent with an administrative-based system, rely to principles like standard of proof, burden of proof, and the principle of proportionality when setting the reaction to infringement. Under this perspective, in my proposal, the Commission have to demonstrate, the antitrust authority and the Commission have to demonstrate parallelism of conduct and anti-competitive effect. So the burden of proof is up on the Commission. And also the presumption of innocence is play a crucial role perhaps when fines are involved. In my proposal, when an antitrust infringement is based just on conduct, parallelism of conduct, and anti-competitive effect, so there is room just to impose remedies and not fine, well, I think that enforcement is proportionate to the offense. And I guess this application, fact-based application, does not perhaps raise an issue of certainty. Perhaps the contrary, make clear that there is an area where antitrust rule can be applied and could likely be applied. As for the remedies, the point is not clear that using pricing algorithm does not exclude antitrust liability, and price algorithm leave traces of their activity. So I expect to be easier to find evidence of information exchange when algorithms are used, because they leave evidence behind. So companies must be more careful than in oligopoly, I guess. On the company's perspective, the commitment not to use algorithm, I think, is quite extreme, because algorithm may have a positive pro-competitive effect. They may commit not to use algorithm able to match the rival price, so to provide automatic reaction. And I think it could be useful if companies establish internal procedure to monitor the algorithm activity used in their pricing strategy, and perhaps they could, on voluntary basis, disclose the code of algorithm, asking for trade secret protection at the same time, in order to show that there was no collusion.
Yes. Yes. Actually, I think that so far we can say that given also the fact that research has done some steps in order to detect the situations according to which algorithms can become detrimental for consumers. So these considerations can be also used in order to implement proper remedies. And in this sense, I think that in order to find a balance between potential efficiencies and potential detrimental effects for competition, it's necessary to identify those specific features of algorithms that can harm competition and ultimately consumers. So I don't think that now we can think about a general ban on the use of algorithms. Remedies can entail 3 different levels of algorithms: the data used to feed them, the type of algorithms, and also the outcomes in terms of prices. So remedies could result in, I think, in a wide set of constraints on their functioning. That can be, for instance, the frequencies of price, according to which price can vary, or a limitation to use of the same algorithm, or, for instance, limitation the usage of algorithms that by design are prone to loosen competition.
Thank you, Chiara. I think we are running out of time. If you have questions, maybe we can pick individually. And so thank you very much for being here, and thanks to our panelists.
Interessante, grazie, molto interessante a tutti.